So what we're going to do here is illustrate what I will often do when I'm towards the start of a mediation in a mediation process which may involve a number of parties, a number of advisors, solicitors, experts and others. So my starting off point is the initial private meetings in each of the private rooms, chatting to people, getting to know them, talking a little bit about what the case is about, but primarily building some rapport and setting the scene for the next stages. My preferred way of working is then to bring everybody together if I can, not to have a great song and dance and a dissertation about what the issues are, but to give people the opportunity to meet. Often people will not have met before. The parties may have done, and last time they met, there may have been a difficulty, anger, emotion. Often people have stormed out of a meeting or it's not been very satisfactory. So I want to try to restore, if I can, a little bit of that relationship. Very often parties will not know, clients will not know the lawyers on the other side, the experts may not have met before, and there may be others who are unfamiliar faces and names. So what I like to do is just to invite people into the main plenary room where we hopefully have bacon rolls or pastries, juice, coffee, tea, biscuits, whatever the host venue is able to provide. And I encourage people to mingle, to serve each other, in a sense it's breaking bread if you like, but building that sense of initial relationship for the purposes of the working that we're going to do that day, the negotiation and the conversations that will need to take place. So maybe allow 10 minutes for that, sometimes a little bit longer because people are moving around and you can see the principals might be meeting and chatting and just getting to know each other or talking about things that they have in common. Lawyers may not have met before, but even if they have, they quite like to chat and just catch up about what's going on and so forth and so on. But after that, my practice is to find myself a position, and maybe at the end of the boardroom table, if it's a boardroom, or as a position where I can be seen by the assembled participants. And I just call a halt to the mingling and the talking, and I just invite them to listen to a few words from me. What I will often have done just in a minute or so beforehand is I've gone to my own private space and just scribbled a few thoughts down, as I've got them here actually on a mind map or a piece of paper, just some ideas about things that I want to say at this stage. And that will be informed, of course, by what I've heard in the private rooms prior to this session, and no doubt what's been in the written summaries, which will have usually been submitted in advance. But this is my opportunity to set the scene and to try to help people to think a bit differently about the mediation process. So what will I usually do to start with is welcome them, thank them all for being here, acknowledge this is difficult perhaps, and that people have had maybe difficult meetings in the past, recognise the work that the lawyers have put in to get us here, and emphasise that this is an opportunity for the principals in particular. After all, it is their case, their dispute, to try to work together with the help of their advisors to move things towards a solution. So let me get into role here and do a bit of role playing. So thank you all very much for being here, and in particular I'd like to acknowledge William and David, Jesse and Peter. You're here representing the two parties, and this is very much your opportunity to engage in this process of mediation, hopefully to the benefit of all concerned. And let me just start off by recognising that this is a matter where there are very different perspectives, where the lawyers have helped you to build up cases and the case is now going to court, as you know, and there are some very apparently strong arguments on either side, although each of you think that your side is stronger than the other. And I might just note here that there's a lot of good research which suggests that lawyers often suffer from what's called optimism bias. In fact, it seems that they are more optimistic about their clients' cases than might actually be objectively appropriate. And that makes sense, doesn't it? Because even if both lawyers are saying that their clients have more than a 50% chance of success, they can't be both correct. In fact, they may both be wrong. It just depends on what a judge or judges may decide on a particular day. So what I want to do is just to recognise the reality. I'll just stop for a second. What I'll do here is I'll draw the cheese, which you've seen before. I'll also draw on a separate sheet the intersecting circles, and I'll talk about them and what they represent and what they mean, as we've seen already in the preparation and illustrations for this course. And then we'll go on and emphasise the opportunity which this presents. And I'll say to people, this is a great opportunity. Most mediations sort themselves out in the course of a day like this, not every one of them, but the vast majority do, in my experience. In fact, I often have to pinch myself when I see the progress that can be made, even from a starting point as complex as the one that you face. But it's also a day of choice, and at the end of the day, this restores to you, decision makers, principals, the opportunity to make decisions about what you want to do and what you want to achieve. Your lawyers and the experts are here to help you, but their role is to help you ultimately to make choices. I will do what I can in my role as an impartial facilitator. I might push, I might probe, I might prompt, but at the end of the day, it's your show and you can decide what it is that you wish to do. You can stay and you can reach an agreement, or if you wish or prefer, find it more acceptable, you can decide not to do so. The benchmark, however, is probably not how much you can get out of the other side or how little you need to pay. It's what will happen if you don't achieve a resolution today. We'll talk perhaps later on about what we know in the business as BATNAs and WATNAs, best alternatives to negotiated agreements, and indeed worst alternatives. And all that means is you've got to look at the cost of proceeding to a court, what that will cost you even if you are successful, not just in money terms, but in terms of time, perhaps in terms of opportunity cost, relationships and contracts foregone, even stress and anxiety, which attaches to all of these situations, however commercial the situation may be. And there are no doubt lots of other factors to take into account here. I know there are reputational issues and publicity that some of you are concerned might attach to this if it became a very public dispute. So all of that in mind as you benchmark whether or not to reach an outcome, which may at the end of the day be minimally satisfactory. It may even be that you both feel somewhat unsatisfied, and that may be a good test of an outcome. What I hope, however, is that you will take the opportunity to optimise the gains that you can make, helping each other to find a solution. Because although in court, in litigation, you're pitched against each other, and the idea is to put up your argument and knock the other one's argument down, here, ironically perhaps, or paradoxically, it's not like that at all. As the intersecting circles have shown, it's your job to help each other. So David and Peter, you need to help those on the other side here to achieve an outcome that works for them, and your counterparts need to do the same for you. And I'm very aware that in a situation like this, there are what we call cognitive biases. What tends to happen is that we form a view about something, we jump to a conclusion, we think that we're right about that. Unfortunately, we're often wrong, because what we've tended to do is to discount or ignore or delete information which is inconsistent with our own conclusions. I'm very aware of that, and would counsel you to look out for new information, to take into account risk which you may not have taken into account fully before. There's also a danger in a negotiation like this that you attach to the individual some sense of what we once say, that sense that they're out to get you, they're out in some way to diminish you. I can't think of what the right word is, but what we call that again in our languages is attribution error. And so that you feel that somebody who's out to get you maybe, let me stop there because I'm running out of words and I've actually lost my thread. So that's interesting, isn't it? So I've got to be careful about just being clear and simple and straightforward. What I'm trying to illustrate here is the idea of a fundamental attribution error, but I've got mixed up with reactive devaluation. So what I would probably say about reactive devaluation is that one of the ways I can help is that when it comes to making offers or suggestions, proposals about settling this case, it's often the case that we'll tend to devalue what our opposite number says because they're our opposite number, and we'd rather think that they may be trying to diminish the prospects for us, and of course the converse also applies. So what I can do is I can be the medium by which offers and proposals can be taken. I help perhaps to give you some balance at that stage in the mediation process. We can talk more about that in due course. Now the question for us here is just how clear was that, because there's a danger here that I'm trying to give them too much information, and myself, not having thought it all through, have become a little bit muddled. So we've got to be very careful when we're trying to bring these ideas about neuroscience and cognitive bias. But if we can illustrate a point simply and straightforwardly to them, using that knowledge that we have, then the more helpful it might be. So at this point, I might then look down to see what else have I not mentioned here. I've talked about roles, I've talked about their roles, I've talked about opportunity, I've talked about choice, I've talked about costs. So I think I might just finish off and say, I often finish off with a quotation. And I think for me this morning, what's come to mind is Einstein. And I'm going to be interrupted here, unfortunately, because I'm doing this videotape, but I'm sorry about that. That's the coffee being brought in, which shouldn't have happened. I'll stop that.